Good afternoon. We will proceed from where we left. There was submission that some of the parties supporting the applications have been submitted.
In the absence, we are happy to start.
Can I start on?
Yes, please.
Yeah. So now, my learned friend Mr. Kibre mentioned Justice Martin during his address to you. And I thought I would mention I thought I would make a reference to Justice. I knew Justice Martin very well. I met several appearances before. But one great quality I thought he had was that he was able to appreciate and take care of human nature. And the human nature was very important in administration of justice. I recall I appeared before him during the time when a lot of arrests were being made in the country by President Moise. And I made an application for bond pending arrest. There was no provision in the criminal procedure code. There was no provision or a decided case in court in the country at all. But still, I made this application for it. And my pleasant surprise, Justice Martin gave me the order for fair pending arrest. And fair pending arrest became law of the country. It helped very much a lot of people who are being arrested during the time that the Ebola was in power. My Lord, what you have before you, I invite you and respect you, that you have to take into account what is happening in the country. Here is Deputy President. The executive is asking for a conservatory order to be lifted. Deputy President is not a small position in the hierarchy of Kenya at all. He has overwhelming political following. Himself and our President, President Ruto, worked together jointly, and they won election. One of them became president, the other became deputy president. In my view, the two are inseparable. And you cannot take one and leave another one at all. The moment, my Lord, you lift the conservatory order, there could be a problem in the country. There could be trouble in the country. Currently, I'm advised the poll rating of our deputy president is 70% in the country. He has won a lot of sympathy votes from those who didn't like him at all. 70% is quite a big percentage. I've taken the trouble to read the students of the United States on impeachment. The first country, of course, that came up with the doctrine of impeachment was the United Kingdom. And thereafter, it was taken up by America. There's a lot of rights here, a lot of cases where a lot of people have been impeached, a lot of officers of the state have been impeached, but none of them has succeeded at all in impeaching a president. No president in the United States has been boosted because of impeachment. We are a young country. We have got our own problems. Problems of extreme poverty. Our people now are wallowing in poverty. They cannot get a meal. Those of us who happen to be in the working class are lucky. People like Camino can talk about going for lunch. There are some people in this country who can talk about going for lunch at all. Or people are in a very poor kind of situation. We have problems of tribalism. We're still a tribal society. We cannot pretend that we are more sophisticated at all. We have problems to do with the conservation. We have got problems around ourselves. Our neighbors are not doing very well. Somalia, Sudan, and etc. They are not doing very well at all. I am submitting you very respectfully. These factors that you cannot afford to ignore. You cannot afford to ignore them at all. And it will be a disaster. It will be devastating for this court to proceed and lift the conservatory order and bring in I don't know very much about what I'm nothing against him. He has never wronged me. And I don't think that he has ever said anything anywhere against me at all. I have nothing against him. But all that we are very much interested in at the moment is to make sure that we have one country. May I remind you of what whenever there has been a departure from the constitutional state or from the constitutional student, there has been a problem. 1988, 81, 82. At the time when a lot of people were being thrown in detention. People like Paul Mister were hiding somewhere else in embassies. I think in embassies offices and so on because of what was happening that to take us out. I was personally in detention at that time. That is the time when we had a in the year, I think 2007, we more or less had also chaos in the country. The point I'm trying to make you, what we have before you, a conservative order, they look a very small, but it's a very big issue when it is looked at and examined, analyzed in relation to the present position we have in the country. If I may say so, and this, which the Attorney General was here, I will tell her very frankly. Those who want the deputy president out, let us assume he's kicked out. There will be the same people who will come and say, President, you must go. President Ruto, you must go. There will be the same people who will say that. That will be opening chaos in the country. My Lord, these are factors that you cannot ignore. In American jurisprudence, they never ignored that at all. When Clinton was tried, with your sense of moving around with it, then wasting, and other women, he had quite a number of women that he was having sexual relationships with and so on. Somehow, as the state continued to adduce evidence, the Americans found that Clinton was becoming more and more popular in the country. Those who wanted to see Clinton impeached had to abandon the idea of impeachment because it was becoming a very, very popular president. And moving him out of the position of president would have brought chaos and misunderstanding to the country. So my Lord, I'm saying to you again very respectfully that please do not try to get the what is it, the conservative order as Madam says and asking for. I hope my little guys have brought to my back. My lady and my lord, the law relating to impeachment is no longer, as I said, a UK affair or an American affair. It touches on the rule of law in a country. It touches on human rights in a country. It touches on democracy in a country. It touches on supremacy of the Constitution, the Bill of Rights, leadership and integrity, separation of power, and the role of the judiciary in administration of justice. My Lord, may I, with your permission, read to you one provision from my little book. This is if I Article 150, page 492, a commentary the Constitution of Kenya, page 150. May I read it to you? 492. This is a commentary in the Kenyan Constitution by our jurists here. And this is what it says. It says some able words here are eye-opening. May I read it with your permission? This article, that is the article that's being referred to, is Article 150, dealing with the removal of deputy president. This article which sets out the situation that a deputy president can be removed, protects the deputy president from arbitrary decisions. What has been taken here is an arbitrary decision by Parliament, by the Senate, and that should not be taken by the court at all. Arbitrary decision of the president in the field constitution. If I may pause here, there's a mention of the president. A lot of problems that we have in this country have been caused by the executive, have been caused by the president. We normally have found ourselves in this hostile area because of the acts and behavior of the president. We must tell it as it is. President Moi forced detention. He acted rashly by putting people in detention. We have had extrajudicial killing because of the president. We have had some other ills because of the president. They are continuing. In the repealed constitution, the vice president could be removed very easily, merely by the instruction of the president. That is true. That's how my great friend and my great friend, Jaramogi Odinga, found himself having to resign because of what was happening. Karanja, Professor Karanja, faced a similar kind of problem. He was kicked out by the president, by the roadside. The vice president could therefore have been said to be at the mercy of the president, who appointed and dismissed them at will. The current state of affairs enables the deputy president to sit a heartbeat away from the presidency, yet enjoy constitutional protection against whimsical sections of the presidency. Let us not forget those wise words, my Lord and my lady. I'm inviting you very, very respectfully. Read those words 24 and 22. And if it becomes necessary, incorporate them even in your own ruling. What is going on now is that the deputy president and the president probably are not getting on very well at all. In my own humble view, for the years I've worked, a person who you are working are not always friends. Sometimes it's something very vehemently, very, very strongly. You may even end up by probably abusing one another, but you still continue to work. You still continue to work. You do not have to be friends to work together. Husband and wife, is there a problem? Husband and wife, and I've handled that case. Husband and wife may be people who don't get on very well at all. They cook separately, food in the house. They sleep in different rooms and so on. But they have made up one decision. They do not want divorce, they want to make sure that the children are brought up in a family. Russia and America are not getting on very well. So. But if you go to Moscow, you will find American lawyers, American medical doctors, American businessmen. If you go even to New York, the same thing you'll find Russians. To have a relationship, you do not have to be friends at all. The fact that the president now and the deputy president do not talk to one another, it does not matter. At the beginning, they were talking very well. They were talking to one another very well. Ratio and Ratio and Dorcas were great friends. Someone who were very happy. They had two wives, two presidents, all of them looking like people of the same family. That is the culture we want. That is the civilization we want. That's the peace we want, so that we make sure that we can develop our economy. But not this kind of quarrels and so on, and where one now is able to convince others that we cannot work together, therefore we must divorce. My humble submission is Lord Eric Ogola, who is here presiding over the case. Please come up with a judgment or come up with a ruling that you are not going to lift this authority order. If you do so, you will be opening a chapter for this country which we may not be able to handle at all. Currently, let me remind you again, the deputy president is enjoying 4 rating of 70% in the whole country. He has attracted sympathy votes from people who like him. And the Parliament or National Assembly, which actually impeached the deputy president, if you go through what happened was a disappointing. It's not something to be emulated at all. If you go to the other house, the Senate, again was a disaster. Can I continue, Mama?
Please, wind up the submission.
I'm winding up. I'm winding up. And I'm winding up on this note. My Lord and my Savior. I have lived enough in this country. I've lived long enough in this country. And in particular in Nairobi. When you hear a rumor, you not be so small-minded and dismiss the rumor. The rumor usually has got some truth. So that when you hear foreign meters will be bribed, don't dismiss it quickly. There will be truth in it. When you hear people were seen with so and so, don't dismiss it quickly. There may be truth in it. This is the ability that Justice Martin had, and that's why he was able to rise to where he was. The ability to be able to know what's going on in the country and so on. We are a corrupt country, and the Besha still controls the country. It controls Parliament, it controls Senate. That is not the state to control the people.
May it please you, Lord President of the Court, the members of the court, we are happy to reply to our colleagues. Somebody has come from the room.
My name is Masongo. I'm here for Australia alongside.
I'm on high demand, so I beg to leave the court. I'm going to give to someone else.
Just a clarification. Last time you got an application from the food area to join, and then you joined.
Yes.
My name is Musongo. Thank you so much. The Lordship and the Lady. As to Sharia, our slogan and motto is that we care for justice. Our intention at all times is to uphold the Constitution and ensure access to justice. And we have been, for the past 50 years, been recorded as an organization that promotes that. For sure, not 50 years, but I do stand on the shoulders of giants who have been there before me. And I want to just bring out 5 points in my experience. Why you shouldn't vacate the orders or fail to ensure there is conservative orders. Number one, in promoting justice and the interest of justice, we have petitioners who are saying that the right to fair trial and constitutional rights have been contravened and violated. It will be so painful for them, genuinely speaking, that conservative orders be vacated, then they continue with the trial. For sure, Article 23, Article 159, Article 27 talks about ensuring equal place. Our argument is that lordships and relations to ensure that their constitutional rights to fair trial, even including during this process, just preserve the few days will be handling the matter, that status quo be maintained, particularly because it is crucial for public interest.
Judges are not guys.
My apologies. My apologies. My apologies. The lordships and the ladyship. To have their rights safeguarded, and at least the courts provide a guideline on how Article 145 is to be exercised. And for sure, we also think that at this point, maybe the lordships and the ladyship, it is important that the court at least safeguards the petitioners who are claiming their rights have been violated, and they need a conservatory order pending the determination and final outcome, so that it doesn't embarrass the court ultimately. When now you make a finding that for sure the entire process could have been flawed, we argue that to also avoid arguments that possibly there would be potential bias, we encourage lordships and relations to really consider that as I wind up, that let's ensure that the annual allegations from both sides are justice is not served. It's imperative that at all times justice is seen to be done in line with Article 159. And lastly, they are arguing, the petitioners, that irreparable harm would be occasional, and it is in the interest of justice that they be afforded that one final bullet, last chance to be able to benefit their rights before the final outcome of this one. I humbly pray that the lordship and the leadership, please do not forget them. Thank you so much.
Thank you very much, presiding judge and members of your court. I want to guarantee you from the outset that we will not use 4.5 hours for the respondent. We will be very, very succinct. Indeed, we may very well use half that time. Every lawyer in this court is entitled to his opinion as to what the law is. There is only one thing they are not entitled. It doesn't depend on their opinion. It is what the facts are. That's where we need. What are the facts that are relevant to you determining whether conservatory orders should continue in force or should be vacated? It is my humble submission that the pertinent, the material facts are as follows. On the 17th of October 2024, the Speaker of the Senate gazetted the removal from office of the former Deputy President, the Honorable Gachagua, by due of Article 157, sub-Article 7. It is important for us to go there, my lord, and it will take half a minute. What is the language of 145, sub-Article 7? It is this. If at least 2/3 of all members of the Senate vote to uphold any impeachment charge, the president shall cease to hold office. That's the language. Shall cease to hold office. As at the day and the time and the minute that Senate voted, the deputy president ceased to hold office. I hope this doesn't disappoint my learned friend Teresia Kimodo of Teresia Kimodo and Company, who wants an apology. The deputy president ceased to hold office. But something else happened. An intervening fact is that on Friday, the 18th of October, via a special sitting of the National Assembly, the Honorable Professor Kindiki Kithure, pursuant to Article 149(1), having been nominated by His Excellency the President, was confirmed by the National Assembly. It voted on his nomination. One person has ceased to hold office, another person has been appointed, has been nominated, and the body entrusted in law in affirming that nomination did so. That was at 1:30 p.m. on Friday, the 18th of October 2024. What then did the honorable judges of the High Court of Kenya conserve? What were they conserving? There was nothing to conserve. In the logic of the law, we can told that a lot about why the Constitution is very important, why it's very special, why it's very transformative, why it's not like the Constitution of other countries. It may very well be all that. But the Constitution is a law to interpret, to be interpreted the way we interpret all laws. When we read a will, we don't start searching for the spirit of the will, because the will is speaking. It is saying, I leave my assets to my son, to my daughter, to my uncle. So a person reading a will doesn't tell the family, before we read the will, let us capture the spirit of the will. If we read a tenancy agreement, we do not say, let us capture the spirit of the tenancy. The tenancy agreement is speaking on its face until there is an ambiguity, which is the same thing with the Constitution. It says what it says until there is an ambiguity. Where is the ambiguity? When the Constitution has said, shall cease to hold office. It is our first submission. There is no ambiguity. There is no reason to search for any other meaning, any other spirit, any other constructiveness. The honorable, the petitioner is aware of that. There is an affidavit here called supplementary affidavit in support of the petition. What does it say in paragraph 22? In this case, however, Kithure Kindiki was unqualified because he had not been a member of UDA political party for 3 months preceding the nomination. He was ineligible for nomination to the elective position of deputy president under Article 37 on the 18th of October 20, when the vacancy arose. This is not the Attorney General's affidavit, it is the petitioner's affidavit. So that his lawyer may be acting contrary to his express instruction, because he has sworn an affidavit